Good afternoon, everybody, and thank you for joining us today. Welcome to our second webinar of the 2017 MSHA webinar series, Understanding the Mine Act and MSHA Policy. As you just heard, the webinar will be recorded today, and I plan to make the recording and a copy of the slides available to you all within the next few days. I'll send that out by email to you. For audio quality reasons, we're going to be muting all the participant phone lines, but there is still a way you can comment. In the lower left-hand corner of the screen, there's a chat function. I'll try to address these at either the end of the presentation, or if they pertain to a subject matter that we're discussing at the time, I'll try and catch them at that point. But with that, I think we're going to get started. And for those of you who haven't listened before, my name is Nick Scala. I'll be your host this afternoon. I am the co-chair of the MSHA practice group at Conn Maciel Carey. I'm also a certified mine safety professional. We represent mine operators and independent contractors here all around the country with MSHA compliance assistance, contest work. We advise and represent companies through any type of litigation before the Federal Mine Safety and Health Commission and beyond, as well as assist in managing incidents, accident investigations, special investigations, and discrimination claims. So with that, though, we are going to move forward and look at our agenda for the afternoon. So what we're going to be talking about is the Mine Act itself and how this came to be, the authority and power vested to MSHA under the Mine Act. We'll look briefly at some of the historical laws and regulations that predated it. Then we're going to look at some provisions of the Mine Act itself that have specific importance to everyday operations, such as the ability to assess penalties and how that is done, and jurisdiction claims, and how jurisdiction of the mining industry is divided between OSHA and MSHA when MSHA came into being. We will then look at the MSHA policy materials, as well as how those materials may affect the policy and enforcement and contest work that we come across later on if there is a citation or order issued. So first, the Mine Act itself. The one we look at today, that is the Mine Act, was issued in 1977. It was not the government's first attempt to regulate the mining industry, although it was the most substantial step in that direction. Back in the 1800s, late 1800s, we saw the first real attempt from the government, and that was to pass a rule that had to do with the ventilation in underground coal mines, as well as not permitting 12-year-olds to work in them anymore. So we've obviously come a long way since that point in time. Fast forwarding a bit, in the early 1900s, the Department of the Interior Bureau of Mines was created, and that still exists, but it is now the Bureau of Mining and Mineral Management, and handles more so on the land development and mining permitting side of that on federal lands. Since then, we saw several acts of substance. The Coal Mine Safety Act, the first one of those, was set in '52, which began some requirements that we still see today, such as annual inspections, penalties being issued for failure to comply with withdrawal orders, as well as the ability to issue citations in imminent dangers. Then, for the metal non-metal industry, the first real tool for the government at that point came out in 1966. The real teeth of maybe what we see as the current Mine Act today was authored in 1969 of the Coal Mine Safety Act, and this would set out some very commonplace requirements that we still see today, such as the 2 inspections per year mandatory for surface mines, 4 for underground. It, like the current Mine Act, was a criminal statute in that the government could pursue criminal charges against agents of management who knowingly and willfully ignored safety and health requirements and regulations or put miners into unsafe circumstances. And also this was the first time in 1969 that we saw all citations having a penalty amount associated with them. So really when you look at it, we had a stepwise function going through it. Since then we had the Mine Act of 1977. Like I said, that is what we're still governed by today. And most recently, additional to that was the Miner Act of 2006, which focused on emergency response plans in underground coal mines, mine rescue teams. It established the 15-minute reporting rule for incidents or accidents that qualify under Part 50, and as well as it increased penalties. We talked previously in one of our webinars looking at what could come, what maybe is the future, and right now, the Mine Act is likely to stay where it is right now, but there is and there has been for years the Bird Mine Safety Act, which floats around and gets reintroduced into Congress each year, which has heightened provisions and protections, building off even more what the Mine Act is. And what we see here is that much like the Mine Act itself and everything subsequent, the Bird Mine Safety Act is likely going to be a reactionary event when and if it occurs ever to a mine disaster, just like the Mine Act itself was enacted shortly thereafter the Sunshine Mine disaster in Idaho in 1973. And in this disaster, there was an underground silver mine in Idaho, and there was a series of fires which resulted in 91 miners dying from smoke inhalation. And after that, we saw the creation of MSHA in the Mine Safety Act, the creation of criminal and civil, and along with that, the creation of the Federal Mine Safety and Health Review Commission as an impartial third party to hear disputes between operators and the government agency. At that time, the Department of Labor, which still now oversees MSHA, was given that responsibility to create the Mine Safety and Health Administration. It was removed from the Department of Interior so that there was not a conflict of interest between their job to develop mining sites in the federal lands as well as manage the safety and health of those sites. We also saw that this was, in 1977, the first time that the metal, non-metal, and the coal mine safety regulations were put under the same document in the same act. So additionally in this, we had warrantless search authority, which is a big element that differs from the OSH Act, or that governing OSHA. Warrantless search authority is the reason that MSHA can come on our properties at any point in time, and we cannot stop them from doing so. They have the ability to come on and inspect for safety and health. If OSHA shows up, it can be requested that they leave and come back with a warrant at a later date to conduct the inspection. Obviously, we do not have that opportunity with MSHA. We also know that, one thing we hear a lot when it comes to warrantless search authority is the advance notice, not informing individuals at your mine or having information or informing anyone else that an inspector may be coming. And that is one thing that we sometimes see confusion about with how advance notice and warrantless search are merged into one. Warrantless search authority, as I said, obviously gives them the ability to come on site, but you're still offered the opportunity to organize your management and those that you should be having accompany the inspectors on site. And that is a situation where advance notice can be abused, or it can be sought to be abused, and operators should always know that when MSHA comes on site, they can mobilize their personnel that are designated to accompany the inspector and meet with the inspector. And doing so should not be construed as advance notice or threatened as a violation of advance notice, unless we're blanket broadcasting across the entire mine on a single radio channel, therefore giving everyone a heads up. So when we talk about this, we're obviously saying jurisdiction. that seems pretty cut and dry, right? Who or what does the Mine Act give MSHA, which it created, jurisdiction over? Well, in the beginning of the Mine Act, it says that each coal or other mine, the products of which enter commerce or their operations or products of which affect commerce, and each operator of such mine and every miner in such mine shall be subject to the provisions of the Mine Act. So what does that mean? That means unless you're going to be determined, and we'll talk about this in a few slides, that you are not a mine or your actions are specifically separated under OSHA jurisdiction, MSHA is going to have jurisdiction over your pit, over your operations. The affect commerce or enter commerce provisions are typical for administrative law and for the government in assertion of jurisdiction over private corporations or private activities, in that if it affects commerce, meaning did you sell it or was it used in some manner that would facilitate the sale of something else or assist in commerce, such as building a road is obviously what much aggregate goes to, or that is going to be considered something that affects commerce, and it is going to fall under this jurisdiction. The Mine Act also contains definitions throughout, and these definitions typically begin each section of the Mine Act, but in the first part itself, it goes to define mines, miners, what is the Mine Safety and Health Administration, what is the Commission. These are very basic definitions, but then if you're having trouble trying to figure out maybe what is the definition of a specific element that is mentioned in your training requirements in Part 46 or 48, or something in a regulation, be it in Part 57, 56, 75, or 77, at the beginning of each section of the Mine Act, there is a definition section with terms pertinent to that area of the Act itself. So we mentioned that there was this agreement, or that there is a division of duties between the Mine Safety and Health Administration and the Occupational Safety and Health Administration, or OSHA. And so this was an agreement, the Interagency Agreement, that's been in effect for quite some time, since right after the creation of MSHA itself. And it goes further into defining what is going to be mining activity and what is included under that. It states that mining is defined as a science or technique of a business of mineral discovery and exploitation. It entails such work as directed to the severance of materials from natural deposits by methods of excavation, quarrying, and hydraulicking. Many minerals so excavated usually required upgrading to process. The latter process is termed milling and is made up of numerous procedures which are accomplished with and through many types and techniques. So what does that mean? It's a bunch of legal talk that really is just saying the excavation of minerals and then some milling are going to fall under the jurisdiction of MSHA. Very rarely are we going to see a situation where you're having any processing other than simply removing stumps, sticks, trash, something along that line, where an operation is going to fall under the burrow pit category, which is not subject to MSHA jurisdiction. MSHA defines milling as one or more of the following processes: crushing, grinding, pulverizing, sizing, concentrating, washing, drying, roasting, pelletizing, to name a few. So if we are going to be challenging MSHA jurisdiction, which is an option if we have an operation maybe where we are only running it for a short period of time, where we are not selling the material. Maybe it's for use on a road project, or it's for use on a construction project that we're doing at that time. we're going to have to look at what jurisdiction do we fall under and what arguments do we have. Borrow pits are the term we typically hear if you're challenging jurisdiction. Are you going to qualify as a borrow pit? Borrow pits are not under MSHA jurisdiction, but instead that of OSHA. And a borrow pit is a area of land where the overburden consisting of unconsolidated rock, glacial debris, and other earth material overlying bedrock is extracted from the surface. It occurs on a one-time only basis or only intermittently for use except for, and no milling is involved except for the use of a scalping screen to remove large rocks, wood, or trash. The material is used by the extracting party more for its bulk qualities and is located relatively near, or for use relatively near, the borrow pit. So what we have there is really a very specific situation, a very specific operation that would not be found under MSHA's jurisdiction. Again, this kind of comes into play if we're looking at a situation where maybe we are removing material for fill on a construction site or in a road building process. And even that, though, is not always enough to fall under the borrow pit category. This has gone to litigation many times before the Commission and before its ALJs. Recently, there was just a case where a company was using a pit for road construction purposes. However, the administrative law judge found that it was a mine, not a borrow pit, because it was involved in drilling and blasting to extract the material, and that the operation was taking place on a more than intermittent or one-time basis, and that it was running 6 days a week to create or process or extract material for this road construction project. But that is a situation where even then, even though the material wasn't being sold into commerce, it was found to be a mine. Specifically, under OSHA jurisdiction, are board plants from gypsum boards, brick, clay, and pipe plants. And then probably more important is asphalt mixing plants and concrete ready mix or batch plants. There has been many situations where, or there are many situations where an asphalt mixing plant or a concrete ready mix plant is on the same property as a mine. Even in those situations, there is a distinction between MSHA jurisdiction and OSHA jurisdiction. And I think it's probably not hard to imagine agencies wanting to extend their reach into different operations on the same property. And, if, for example, MSHA wants to inspect your ready-mix plant or your asphalt plant on the mine site, we need to be knowledgeable enough to inform them that that's not permissible, that that is beyond the scope of their jurisdiction. Now, there have been rumblings that MSHA wants to kind of make a push to get asphalt mixing plants under their jurisdiction because so many are located on mine sites. However, that has not happened yet. And the industry really does need to, though, be diligent in checking any possible expansion of that reach across that jurisdictional line between the two agencies. So another key element outside of the jurisdiction over the mines was the assessment of penalties. And the assessment of penalties is in Part 100 of 30 CFR, the Code of Federal Regulations, that are for mineral resources. And in this, it provides that MSHA can propose civil penalties, and the purpose is to provide fair and equitable procedure for the application of statutory criteria in determining proposed penalties to maximize incentives for operators to prevent or correct hazardous conditions and to assure the prompt and efficient processing and collection of penalties. Okay, so that is the preamble, and that is the first section in Part 100. What does it mean? It means that when Congress wrote the Mine Act, they determined that the assessment of civil penalties attached to each citation and order was going to be an incentive for mine operators to not have similar citations or similar hazards present on their mine anymore. Obviously, that is something that we've seen the assessments change as years go and how they are assessed. But at its heart, the MSHA, the Mine Act, assess based on 6 criteria. The appropriateness of the penalty for the size of the operator's history of violations, whether there was a negligence or the operator was negligent, what is the gravity of the violation, the good faith in achieving rapid compliance or abatement of the violation, and the effect of the penalty on the operator's ability to continue business. When we look at those criteria, we should be seeing some terms that ring a bell in what we see on an everyday citation. When we look at the citation, there are going to be classifications for gravity. Now, on citations themselves, gravity is boiled down into 3 different classifications, which is injury or illness. The injury or illness could reasonably be expected to, and the significant substantial designation. So when we're looking at likelihood or the likelihood element of gravity, we obviously know there's 5 categories, and there is no likelihood, unlikely, reasonably likely, unlikely to occur, and occurred. Similarly, there is in the injury the different designations ranging from no injury to fatal injury as a possible outcome. Same with negligence, ranging from no negligence to reckless disregard. But what we're looking at in there is because these are criteria that feed into the penalty assessment. And these are criteria that look at the point scale, because each one of them has a point value associated with it. If we look through 100.3 of 30 CFR, and you probably have all looked at it at one point in time, we can see that MSHA assigns point values to almost every one of those criteria. They look at and assign a point value to the size of your business, whether by the hours you've worked or the tons you've mined. They look at your previous violations through their violations per inspection day or their repeat violations per inspection day, which are both categorized on your proposed assessments under the history tab. The difference being that repeat violations per inspection day only accrue when you've had 6 or more of the same citation in a preceding 15-month period. Then you'll start accruing penalties points for that, which increase your fines. Same though with gravity and negligence. And the good faith portion we can see is if we have on our proposed assessment that 10% good faith reduction at the end of it. Now this almost is always tabbed on to our assessments or taken into consideration for the assessments unless there is an unwarrantable failure, meaning higher negligence, or an injury or fatality. But the penalties themselves, there was a lot of talk about how this may change with the Part 100 reform that MSHA was mauling over the last few years. Most recently on their regulatory agenda, that has been removed from the prospective rules. It is no longer pending its final rule designation, which is a good thing because that would have fundamentally changed the way that the citation was written. It would have been aimed at reducing litigation, was MSHA's goal, by reducing the amount of categories that were available for negotiation post-issuance. In my opinion, this rule, if it had become final, would have actually increased litigation due to that. And it would also, most people believe, would have significantly increased fines on all but the smallest of operations. But that wasn't the case, and we're still with our original 100.3 calculations where we look at the penalty points. And the penalty points in this go up to a 208-point scale. The penalties start at 60 points or fewer. That is the minimum threshold, and it's a $129 penalty after the last 2 inflation adjustments of the last year. We can see this is a bit of a logarithmic scale in that it increases more steeply as you get up there. So if we are looking at the 60 to 140 points, so the 80 points separating the highest, the minimum, and the maximum penalty. We see that it goes from 129 to 1429 as the penalty in the first 30 points, from 60 points to 90 points. Then we see from 90 points to 120 points, it increases a lot more. We see that it goes up from around $1,400 to $15,000. And in the last 20 points, we have the penalties going from $15,000 all the way up to the statutory max for regular assessment, which is now $69,417. So when we are looking at it, the Mine Act gave the regular assessment templates, and it really kind of laid out how those fines were going to go. And the fines were increased in 2006 and with the Minor Act. They were again increased, some of them in 2007, and then most recently, last year with the Inflation Adjustment Act, the penalties were raised again, lowered in some cases, such as the maximum, which was $70,000 until the inflation adjustment. And then, but that's looking at if we just have normal citations regularly assessed. The Mine Act also provided for special assessment. And special assessment occurs if we look at section 100.5, the first provision, if MSHA determines that the conditions warrant a special assessment. That obviously doesn't give us a lot of guidance on what is going to be specially assessed. We've seen some trends over the last administration. Obviously, we saw special assessments come into play a lot more often, especially in the last 4 years. And what are special assessments? Special assessments means they're no longer bound to the points associated with the scale. So a 60-point citation does not have to be $129. It can be $70,000 or $69,000 if MSHA determines that there was aggravating circumstances that they want to take into consideration. Typically, we see special assessments in situations where unwarrantable failures are involved or there's high degrees of negligence along with an accident or an injury or a fatality. We even see them when there's rules to live by standards with a higher negligence. They get reviewed for special assessments to see if that's necessary. We really know that this is based a great deal, much like unwarrantable failures, on what negligence is assigned. And really, special assessments have kind of, in my opinion, been used as a bit of that middle ground between an unwarrantable failure, where it may not be the grounds to have an unwarrantable failure, but it can still be recommended for special assessments to get the penalty up a bit higher. We see that, if we are talking about unwarrantable failures, those are the more severe actions, not your typical 104A citation, but the 104Ds and D2s. Those penalties were also increased. But, that also looks quite a bit on what is the negligence and how much was a condition known or should have been known, as the MSHA definitions for negligence include known or should have known, with mitigating circumstances, no mitigating circumstances. And that comes back to the strict liability nature of the Mine Act. And by strict liability, what we're talking about is that operators when used in this way include both production operators and independent contractors on a site, can be held liable for any violation of the Mine Act that occurs on site. So that being said, a production operator can be held liable for the violation of an independent contractor. And in some circumstances, the same is also true, that an independent contractor can be issued a citation for a violation caused by the production operator. But this comes back to the strict liability nature when we're looking at negligence. And that is why we always hear MSHA talk about mitigating circumstances and what mitigating circumstances are present. Because since they have strict liability, findings of no negligence are quite rare, because there's always going to be some. MSHA can also always assert that the agent of management or the companies should have known of a condition. So we want to look at the mitigating circumstances, such as what examinations were done, what precautions were taken, such as training, vetting of personnel, things along that line when we're looking at a negligence or considering negligence designations. Lastly, the Mine Act also in 100.5, if we look down at the bottom of the page in Part E, offers opportunities for flagrant designations on citations. And this increases the max penalty. It goes much further beyond the $70,000 statutory maximum. And actually the maximum for a flagrant violation is now just shy of $255,000. And a flagrant violation is even more so beyond an unwarrantable failure. It's even more so beyond a reckless disregard to negligence designation, although those are usually accompany each other. But it means a reckless or repeated failure to make reasonable efforts to eliminate a known violation of a mandatory health and safety standard that substantially and proximately caused or reasonably could have been expected to cause death or serious bodily injury. So in situations where maybe there is just open and obvious hazards, and maybe it's many of the same hazard, we can see flagrant violations come into play, and those are going to be specially assessed, and those are going to no longer be bound by the $69,000 statutory maximum. So additional to the Mine Act's powers or provisions is Section 110 of the Act. And Section 110 is the section referred to when MSHA conducts special investigations, and namely investigations into liability against agents of management or individual agents of management at the company. Dependent upon the allegations of negligence or the nature of violation, MSHA can conduct investigations into this and can pursue both civil and or criminal penalties for the actions of management. Now, criminal penalties, it's important to know that the Mine Act is actually a criminal statute in that they can pursue criminal penalties. However, that is very rare, very rare. The civil penalties, though, have been pursued more frequently in the last 4 or 5 years, and that means that MSHA can investigate, and if they determine it's inappropriate, personally fine, so assess a penalty against an individual agent of the company. This could be multiple presentations and multiple hours of discussion, so to really try and just outline maybe, some advice here. If you are going to be the subject of a special investigation, or as an agent you are named in the unwarrantable failure, limit your participation in the MSHA investigation or inspections as much as practical moving forward. If there's someone else who is trained by the company to handle the inspection, I would advise that to happen. Do not sign statements without reviewing them to make sure that every element of the statement is entirely accurate. As advice, I would recommend that if you do choose to interview with MSHA, which you do not have to, you can decline to interview. You can also have anyone with you during the interview. Do not do an interview alone. Importantly, though, if you're going to be the subject of a special investigation and you're an agent of management, I would recommend that you consult with, some kind of legal counsel, whoever that may be, someone such as myself who specifically deals with MSHA litigation, whether it's an in-house counsel that your company may have. This is a serious situation that, we don't want to let it get more serious. If we can handle it and there's an easy explanation, obviously that's the best avenue to approach, but we have to be guarded in how we do so. at the special investigations, probably the most important tool is going to be the review of records that will inevitably occur, as well as the interviews of minors and other mine personnel. So, make sure that your minors are trained on their minor rights, know that they can participate or cannot participate to whatever extent they want. Also make sure that your records are maintained per MSHA's requirements, so that you can produce what is needed and don't have to worry about that. Never recreate or create new records or forgeries of records. That's a very, very quick way to have a criminal investigation started. But again, 110s could be a entire webinar. I believe they even are later this year if you're joining us. But that is a power afforded to MSHA to do these investigations and look for agent liability. Similarly, the Mine Act provided MSHA the ability to pursue and protect minors' rights and discriminations. It includes the authority for handling and prosecuting retaliatory action by mine operators against minors reps, or applicant minors who believe they are punished for protected activity. So what is, just the very basics, what is protected activity? Protected activity is going to be something like identifying an MSHA hazard and being fired or suspended, or a hazard that MSHA would consider to be requesting an MSHA inspection or filing a hazard complaint with the agency. That is going to be protected activity. We cannot fire or discipline anyone solely for that reason. Refusing to engage in an unsafe act. These are protected activities, and they go much further beyond this, but these are some of the basics that are protected under the discrimination clauses that MSHA has. Additionally, they can do hazard complaint investigations, and there's two types there. There's a written hazard complaint and a verbal hazard complaint. The investigations, typically are going to be called in to an MSHA field office, and then they can come out based on those and have a list of allegations to run through at the mine. And we want to make sure that we always get a copy of this, that we're prepared, and also this ties in closely with what we just were talking about on discrimination claims. We cannot therefore, investigate who made this claim and take action against them, because then there can be a discrimination charge as well. Okay, and lastly, the last provision we want to talk about is judicial review. As we said, the Mine Act created the Federal Mine Safety and Health Review Commission. The commission is a 5-person commission. Currently it's 4. That hears cases on appeal. Below that is the administrative law judges, and that is who, if you go through the formal contest process, your cases are going to be with through the initial hearing. If you want to appeal a decision, you'll go to the commission, and then, as we can see in orange, if you want to continue contesting through the commission, you can do so to the federal circuit courts. So you do have the ability to challenge each and every citation that's issued, the requirements for different citations or non-assessable citations. You got to be a bit more proactive in how you contest them and make your notice of contest known within the first 30 days since issuance. But anything that is assessed, you're going to get that proposed assessment in the mail, and you can contest it. All right, so those are some of the basic provisions of the Mine Act. I know we moved through them quite quickly, but those are some of the foundation or corner pieces that really we have to deal with, because they give MSHA a lot of their teeth and give MSHA a lot of their power. Additionally, what we want to know, though, is we want to be aware of the provisions of the Mine Act, obviously, because those are going to be educational on us being proactive operators and proactive miners and having our operations ready. And part of that is also going to be looking at the MSHA policy. MSHA not only has a book of regulations in 30 CFR, our regulations, whether it's Part 56 or Part 57 for metal, non-metal, surface and underground, or 75 and 77 for coal, surface and underground. Additionally, MSHA has policy out there. And what is the policy? Policy is not strictly enforceable like a regulation. You're not going to receive a citation that has a policy cited, but they are used to clarify expectations or what constitutes a hazard from MSHA, and also, what operators should be able to do or should not be able to do within MSHA's interpretation of a standard. So the big one is the Program Policy Manuals, or PPM. They're listed, all of this information is listed on MSHA's website in access to the volumes, but there's 5 volumes. And we can see that they cover everything from the Mine Act to coal and metal non-metal standards. If you go through the coal and metal non-metal standards, you can search it by a specific standard number. So if you receive a violation under 14100, you can look it up in the policy and see if there's maybe some information that applies to your specific citation, or a citation that the inspector told you he plans on writing later that day or later the next day. If you are going to contest or you want to contest a citation, the Program Policy Manual should really be one of your first stops to check and see if there is any guidance about that. It contains material with long-term or continuing application to the MSHA programs. Not every regulation has a program policy interpretation, but those that do, it can provide clarity on what's expected or what is permissible. Don't be surprised, though, that they always have a bit of a clause towards the end that is based on these circumstances or dependent upon circumstances, because just as the MSHA standards themselves are pretty vague, offering a wide breadth of interpretation and enforcement, they don't want to be hemmed in by the policy, so they're going to say that it is dependent upon the circumstance. So even if that policy says one thing, they can go against it if they believe the situation demands it, and we'll cover that with a pretty concrete example here in the next couple slides. But it's important to know the policy is not binding. It is persuasive, it is going to be guidance, but it is not binding. So it is not a get-out-of-jail-free card at all times. Program policy letters are different than the Program Policy Manual, and these are released every so often, a couple per year, and they are going to be published on the MSHA website. Also, I think they email them to you if you're subscribed on the MSHA website. But they're going to be focal points on enforcement, typically. They're going to be items that supplement the policy manual. They're going to be, again, guidelines or expectations from the agency. Some that come to mind are prior to the workplace exam rule, which is now a final rule coming into effect in May, unless the new administration takes some action beforehand. There were a couple of PPLs on the workplace exam expectations from MSHA and the metal non-metal industry, talking about task training for the competent person, talking about expectations on what should be found and noted. Now, it was not changing the regulation itself, what was already written in 57, 1802, or 18,002, but it was providing guidance on how MSHA was going to be looking to enforce it within what was written there. And again, that's because of the broadness of the standards themselves. Most recently, there was a program policy on suspended loads for metal and non-metal industry filed just this past week, last week, and I believe, my apologies, I think that's actually 16009, not 99 on the standard, but that was just recently released. Other materials in the policy that we want to take some time to look at, and these may not be as important to everyday enforcement, or particular standards, I should say, but are just important for everyday enforcement, especially the MSHA handbooks. The MSHA Handbook Series is background information on inspector training, procedures for conducting inspections, conducting investigations, excuse me, also for writing citations and orders, how and what MSHA trains their inspectors to look at for determinations of gravity and negligence, and also in how to defend them moving forward. So we want to look at, these handbook series, and there's multiple of them. There is not just one handbook, and it's a whole handbook series page on their website. But I would recommend taking time to read through some of these, and we could probably even do a presentation just on the handbooks. But they give very good details of what MSHA is expecting the inspectors to do when they come on site, such as the opening conference, and the closing conference, and reviewing the citations and minors' rights, and presenting the written citation to the operations. Those are all going to be included in the handbook series and are good tools for everyone to look at, especially if you might be new to the industry or new to MSHA's jurisdiction over the industry. Also, there's program instructional letters, or procedural instruction letters, and these are more internal memos for the agency itself, but again, every now and there is some tidbits in there that are applicable for the industry and for private industry. The information bulletins are, again, going to be more kind of handbook updates to inspection procedures and administrative matters within the agency itself. And then lastly, there's compliance guides. And these are very good in that they provide, on a specific topic, a question and answer series that are going to be things that industry and comment period, things like that, have submitted questions to MSHA on their interpretation or their opinions of a rule or a certain piece of equipment or operation procedures, or there's quite a bit on the compliance guides about the underground mine rescue and refuge alternatives and things like that, but what is going to qualify and what the agency sees as their interpretation of those questions. So it's a good place if you have questions about a certain topic to go review these areas, and there could be some material pertinent to exactly what you're looking for. So how does compliance or policy influence enforcement? So what we mentioned earlier is still true. Policy is not binding. Whether it's the program policy manual or the program letters, it's not going to be binding on enforcement. They're always going to give themselves that get out of jail card in the back end of the paragraphs. So, one that we saw a lot of pushback from or a lot of confusion with was when MSHA put out the program policy letter on safety belts and lines for metal, non-metal a few years ago, and said in that they will look at the MSHA 6-foot rule for guidance. Well, or OSHA 6-foot rule for guidance. Well, MSHA standard says that fall protection must be worn when there is a danger of falling. It assigns no height requirement. And then in that program policy, we can see that MSHA put at the bottom in that orange paragraph, the last sentence, MSHA will evaluate all work area hazards to ensure the appropriate fall protection provisions are in place to protect miners from fall hazards. And in the beginning, the first sentence, it says, in many cases, compliance with OSHA's protection will satisfy. So, I put that in there specifically to show that there are escape clauses, and many companies and many people tried to contest citations at the time that MSHA issued this program policy letter saying, my person was 5 feet above the ground. Why are they being issued a citation? Or, that is within the 6-foot rule from MSHA or from OSHA. And, MSHA still issued citations, and they still can do so. So they're looking at a specific set of circumstances. Is there dangerous materials underneath? Are they working on a platform where they're 5 feet above the platform, but then there's another fall? those are kind of what we see though in the policy. They are very helpful, but we can't be too reliant on them because they are not a shield for any citation related to that topic. We also know that MSHA, and again, this comes down to in litigation, and when it comes to these policies, there's going to be a lot of deference paid to what MSHA and what the Secretary of Labor, or through MSHA and the Solicitor's Office, interpret in terms of how the standard is enforced. And this is because of a very big Supreme Court decision called the Chevron Test. Now it's called the Chevron Test, where it was found, the court held that most courts, or all courts, should defer to agency interpretations of statutes unless they are unreasonable. That's obviously a very simplified explanation of the Chevron Test, but it gives the agency the leeway to interpret standards the way they want to, and that's also why they can say, well, we have this policy that says A, but under these specific circumstances, we don't think it applies. So the policies are always good. They should always be a first step when we receive some enforcement action to see if there's policy that gives us a defense, because this can help us in terms of negligence or gravity in the designations. But just don't look at it as an absolute shield, as something that's going to protect it and have every citation that's related to it thrown out, because that's not the way that they've been written or the way they are going to be interpreted by the court system. But bringing up these contests early, or your reliance upon a policy early, can sometimes be a proactive way to maybe move past it or get an abatement extension on a specific element. So one recent one that we talked about, the program policy letter put out this past week, has to do with suspended loads and working beneath suspended loads. And in that program policy letter, MSHA does not, or in the policy letter, MSHA goes out to say that the term load is not defined by the agency in the standards, but that they are going to include equipment or rigging that is attached to a crane wire, such as a spreader, load blocks, ropes, swings, shackles, as load equipment and as part of the load when their standard says you shall remain clear of loads. Now they did say that they are going to provide some opportunity if you are a rigger or a miner attaching the materials to the suspended load or attaching the rigging blocks to the crane. But again, it's going to be narrowly construed as what that is. There was a case that talked about this specifically just last fall. The decision came out, and it was called the operator was Sims Crane, and in that decision, the judge stated that by walking underneath a spreader bar, which was suspended, a rigger had violated the standard of walking beneath suspended load. And the argument was very similar in that case, that the spreader bar was not a suspended load. Well, obviously the agency took note of this case, and this case is actually, if I believe, it's on appeal, so maybe this policy will come into play at that. But I think there's some distinguishing factors that may, again, give MSHA that get out of jail free card on it. But in this situation, the court upheld a decision where MSHA interpreted that being beneath the spreader bar was a suspended load. Now they're saying that when attaching it, you may not be under a suspended load, but what does that mean if it goes straight up? Are you still standing there? Are you in the fall zone? So these are, though, good because we want to know that. We want to know that MSHA is looking now at this particular standard and these particular activities. We should be proactive in training or having a safety meeting with our individuals about this development, and know that it is also probably a precursor of what's to come in enforcement. This is going to be something that's paid attention to by inspectors moving forward. And so, with that, we are finalizing. I know we've covered a lot of information. as I said, we always are going to post updates on our blog, and I'm happy to answer any questions now or at a later time if someone wants to reach out to me. And we are going to be open for questions right now if anyone has them. Okay, it looks like we do not have any questions. I apologize to those individuals. I see some questions regarding the audio. I hope that figured itself out, but I will be sending out the recording shortly. If not, and if you have any questions on what was covered, please feel free to contact me. So I hope you all will take the time to join us for future webinars, and thank you very much for your time. Have a great day.